Hello and welcome to Just Liberty, where justice and liberty meet. I'm Bettina Krause, editor of Liberty Magazine, and with me is my co-host, Alan Reinach, who is executive director of the Church State Council. And together we're trying to reclaim religious liberty from the political extremes, which is a pretty big ask, right, Alan?
It certainly is. And especially in a topic like we're going to look at here in the show today,
Absolutely.
which is the right of Christian parents or Christian couple to be foster parents.
Right.
And there's a case filed by the Becket Fund on behalf of a Catholic couple who were grilled on their faith, their views on sexual orientation, on marriage, on transgender issues, and they were excluded from being able to be foster parents because of their faith.
So, I mean, and this is what I wasn't really clear on with this case. I mean, is it because of their religious views per se, or is it because the people who were doing the interview felt that if a child experienced gender dysphoria in the future, that they wouldn't support them in a gender transition or something to that effect? Or was it simply their religious belief? I mean, what was at issue here?
Well, the case is still early, and I'm not sure that we know the facts exactly. But even assuming that it's, well, if you happen to foster a kid who has gender dysphoria, are you going to treat them the way the state thinks you should, or treat them the way your faith thinks you should? Because, there's a disagreement. And what are the odds?
So it's an entirely speculative issue, right?
I don't
know.
I don't know how many. I don't know how many kids in foster care experience what we call gender dysphoria, or how likely that is to happen. But it would seem to me, just kind of thinking about it as we're talking, that kids could go back to the foster care agency and say, hey, something's not quite right here. And seek a different placement.
There's recourse.
That on kids, right? We need more foster parents, not fewer foster parents.
Right.
So why do we exclude some? We've got too many foster kids who need parents. And if you have people who are prepared to be loving parents, you're going to exclude them because of a what if?
Yeah. Well, I mean, this is not a unique case. We've seen cases like this in the state of Washington, in Oregon, in other states as well, where parents, prospective, either adoptive parents or foster parents, have been, their views about sexuality and their religious beliefs about it have been, at issue, and seem to have been the reason why they've been denied the ability to participate. So I guess this is one of those cases where, I mean, we're just seeing the beginning of a wave of similar cases, and it remains to be seen how the courts are ultimately going to deal with them.
Well, and it strikes me, Bettina, that this case reminds us that there is plenty of intolerance on both sides of the culture wars, right?
Right.
Because you have those on the left who are very much my way or the highway, and you either go along with our, gender and sexual orientation agenda, or you don't have any rights. And the response to that among some on the right has been, no, you folks are the ones who are out of line and out of touch, and we don't think you should have any rights. And somehow there has to be a way forward in a free society for people to have different values and beliefs.
Absolutely. There's got to be room for dissent, and there's got to be the ability for whatever your opinion is, to respect and live with the people who hold opposing views.
And I think it goes to the question of, what is religious freedom really? Is it the right to believe as I do? Or is it even the right to be wrong, at least as I may think you're wrong, right?
Well, we're going to sort of touch on some of those issues in our interview today, Alan, with someone who I think you're going to find really interesting, Professor Charlie Russo. Shall we bring him on?
Please.
So we are delighted to have with us today Professor Charles Russo. He is the Joseph Panzer Chair in Education at the University of Dayton, School of Education and Health Sciences, and Director of its PhD program. And he's also Research Professor of Law in the University School of Law. And he is a prolific author with more than 325 articles in peer-reviewed journals. And he's authored, edited, or co-edited some 73 books. He's also an internationally renowned speaker on issues in education, law. And he's been invited to present in more than 30 countries outside the US. So welcome, Charlie.
Tina and Alan, thanks very much for the opportunity to be here. I look forward to chatting with you as we did before we started.
I'm already tired just listening to your bio.
There's over 1,300 publications. I'll send you my CV.
Oh, yeah. Do I have to read it? Only if I don't have to read it.
Charlie is actually a contributor to Liberty magazine, and that is what has inspired this interview. He recently wrote an article on the ministerial exception. So, Charlie, why don't you just explain to listeners who may not have heard this term before, what is the ministerial exception? How does it help, in particular, faith-based schools?
Sure, Bettina. Thanks very much. Good question. The ministerial exception is actually grounded in the First Amendment. The first 16 words of the First Amendment read, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The ministerial exception was embedded in Title VII of the Civil Rights Act of 1964 that passed actually tragically after John Kennedy was killed. There was a great deal of opposition during his lifetime. And I suppose one might say in sympathy for Kennedy's passing. It made it through. But from some of the histories I've read, it's got a really interesting political history. This is not a political statement. It's a statement of fact that I think is that I know is verifiable. The Democrat South really refused to vote for the Civil Rights Act because of how it was going to treat people of color. And so the Democrat presidents needed the help of the Republicans. And one of the people they checked with was a Monsignor Hochwald, who happened to grow up here in Dayton, Ohio. I just learned that recently, asking Catholic politicians for help in terms of getting the bill passed. And politics being what it is, one hand washes the other. So Hochwald asked, my words, not his, but what's in it for us? Well, the what's in it for us was in part the ministerial exception. And the ministerial exception has 4 parts to it, but the most important part is the one we're going to talk about here, is that if a faith-based employer can prove a so-called bona fide occupational qualification, a bona fide occupational need for people to meet certain requirements, then that person is subject to the decision-making of religious authorities, not civil authorities. For example, if one, and the case we're going to talk about, I don't want to jump too far ahead, but in Christiella versus St. Teresa, it involved a woman who taught in a Catholic school, and Catholic school church teachings and many Christian church teachings are that women should not get pregnant outside of marriage. And so if a school can demonstrate that there's a bona fide occupational need for doing that as a role model, plus in this case combined with the fact that she signed a contract, then the courts have said we don't have any jurisdiction here. We're going to back off and allow religious leaders to make those determinations as to who qualifies as ministerial. Now, that being said, and I'll talk about this a little bit later, I think, in one of your other questions, in the last dozen years or so, 11 years to be exact, the Supreme Court addressed the ministerial exception twice and upheld it. I'm a supporter of the ministerial exception for what that's worth. I think it makes sense. I agree with one of those outcomes, but not the other for reasons I'll talk about in a little bit. Let me stop and try to follow the sequence that you've answered. Have I answered your question, or would you like me to follow up any more on that? The goal of it is to protect religious autonomy.
Right.
To allow
Right.
religious authority to make those determinations as to who qualifies.
So drawing a line between what's appropriate purview of the state and what's appropriate purview of a religious organization.
I think that's fair, yes.
Yeah.
Well, the courts are going to stay out of decision-making as to the relationship between a religious body, a church, say, and its clergy. That's the core. They're not going to say, for example, whether a black minister should be permitted to pastor a Hispanic or a Korean church or what have you, right? Church authorities can make religious-based and race-based or any other based decision as to who's representing them. That's kind of the core part of the separation of church and state, if you will, that the courts stay out of these kinds of religious decisions, right?
Exactly. A case I wrote about for another publication, Bettina, where actually 3 cases from Pennsylvania and North Carolina, male teachers in those cases have entered into same-sex marriages, which again is outside the teaching of the Catholic Church. So far, the schools have won 2 of the cases, but the one in North Carolina, the teacher won. And that's still before the Fourth Circuit. So, as we say, that check's still in the mail.
Well, what I'm finding, Charlie, is that if and when the ministerial exception is taken too broadly, that trial judges push back, and they don't think it's fair, and they'll let juries decide. They won't throw cases out, because the point of it is to insulate churches from being sued in the first place. But if the judges think that the doctrine has gone too far, and you intimated that there were cases that you disagreed with, that I agree that it's gone too far. I'm a strong supporter of church autonomy and church hiring practices when it comes to those who really represent the church. But we can talk about where you think it's gone too far.
In 2012, Lavetta Tabor was a case from Missouri, and a called teacher, put called in quotes, which meant that she had received additional training, she received additional salary, she received additional benefits, not the least of which, as silly as it sounds, was a reserved parking spot and the like. She got into a dispute with officials at the school, and the court decided it's not on religion, not under the Americans with Disabilities Act. And she was out for an extended period of time, and because she was called, the issue was whether they had the authority to dismiss her, despite her allegation of discrimination based on her disability. And the Supreme Court unanimously, and you know as well as I do how often, it's a beautiful day here in Dayton. And if I stood the 9 Supreme Court justices here and said, look out the window, I'd be surprised if I'd get an agreement that it's a beautiful day out today. But in that decision, even Justice Ginsburg, who was pretty much a strong separationist who believed in the wall, recognized that because this woman was called, because she had this special position in a hierarchy, school officials had the authority to dismiss her from her position. 8 years later, companion cases, which, as you know, are 2 cases on the same issue, Our Lady of Guadalupe versus Morrissey Berriew and St. James School versus Beale, 2 teachers in 2 different Catholic schools in California filed claims when they were dismissed. One teacher's claim was age discrimination. The other woman had cancer. And unfortunately, the second teacher passed away from her cancer, and her husband continued to sue. Now, something that we didn't mention before, and there's no need to really, is that in addition to my law degree and doctorate, I have a Master of Divinity. I tell people I'm an incomplete person. I have a seminary degree, but I'm not ordained. I have a law degree, but I don't practice. And I have a doctorate, but I run from administration. If there'd been a job market, I'd have had a PhD in theology. It was my first love. But if one follows Roman Catholic Church teachings, I kind of wonder where is their consideration for people who are ill and disabled. So while I support, like you do, Al, the ministerial exception, on the facts of those 2 cases from California, it surprises me that the Roman Catholic Church, of which I'm an active member, relied on civil positive law ahead of church divine teaching to deny these two teachers employment. So in an article I wrote for another journal, and I'm sorry, I'll stop 1 second, with a friend, we called it Right Test, Wrong Outcome.
So, Charlie, the attorney representing both of those clients is a close friend and colleague of mine.
Oh, really?
We have litigated many cases together. We have lunch together regularly. I helped him evaluate those who would argue the case and litigate the case before the Supreme Court. Because with you, one of the teachers was not even Catholic. To say that that it's a requirement that you're a minister if you're a woman teacher in a religious body that does not recognize women as clergy, and not even a member of the faith, and yet somehow you lose all of your rights as an employee. That struck me as a bridge too far.
And again, I largely agree, but let me just look at it from another angle. The Roman Catholic Church, and I was a Catholic high school teacher for 8.5 years between degrees, also takes the position that teaching is a vocation. That by being in school, you're a representative of the church, and that you must accord yourself with those church teachings, and that while you need not be Roman Catholic, you need to at least comply. And I don't believe either of those teachers failed to comply. Their disagreements were over their disability condition. That's why, again, I think the ministerial exception is proper. But on the facts, I think the court got it wrong. But they were more concerned, I think, with preserving, as you said, Alan, the autonomy of religious officials to decide who qualifies. And so they deferred, perhaps too greatly deferred. I think you and I would agree. But I don't know about you, but I would rather that the courts go a little too far in defending the religious freedom than not.
You know, there's actually two provisions here that sometimes get confused, because the statute, Civil Rights Act that you mentioned earlier, Title VII, that gives a certain type of immunity. It says that religious employers can make religious decisions. So if, for example, the teacher was in violation of, for example, in a same-sex marriage, and that was a violation of church teaching, then the church has a right to invoke its teaching and discriminate on the basis of religion. But these cases involved age and disability. They did not involve religion. That implicates a First Amendment principle of the ministerial exception that says, as a matter of First Amendment doctrine, the state stays out of the business of dictating to the church. But that should be a much narrower range of individuals, because it's such broad immunity, where they can fire somebody that, you know, is blatant age discrimination or disability or gender or race or any kind of discrimination, but it's because of the role of those employees as representing the teachings and the policies of the employer.
Yeah, so I mean, it sounds like both of you have problems with the concept of the ministerial exception being applied more broadly, but you believe that it is an important tool that religious organizations have to preserve their identity. How would you then define who a minister is for the purposes of this exception? Because that really is the crunch, right?
Sure, another good question. Let me back up then. I have, as you might see behind me, I have a case book on school law. And it's not because I taught there, but there's a case from New York City in the early 90s, DeMarco versus Holy Cross High School. And the guy was a math teacher. I had taught there in the late 1970s, right, until I went to law school. And he filed an age claim, I think it was, because they dismissed him. And the court ruled, no, you can't file that claim. This had nothing to do with the job. He could file that claim. It was not ministerial. This was a matter of age. What I would like to have the court look at, I'm not sure I could give you a precise test, because most of these are, written in Jello. Is that you have to take a look at what the underlying position that the person occupies. Also, what level would you teach? Certainly, I think a teacher in early childhood, kindergarten, first, second, third grade, religion is going to be an integral part of what they do. But a math teacher or a science teacher in a secondary school should probably get a little bit more deference to what he's teaching as a subject. That being said, I think the conduct of educators that is open and notorious to that which we could observe, they have to comply with church teachings, even if they're not members of the faith. That you can't go out and I worked with a guy who would come in the locker room, might as well have been in the faculty room almost every morning. He'd come in and brag about his exploits with his date the night before, and he would talk about that in class. That's inappropriate. He should be dismissed. There's no grounds for that. But if I'm a math teacher and I file an age discrimination claim, I have a hard time saying that's ministerial. Does that make sense? Again, I can't give you a precise test, but I think we have to look more carefully. On the whole, the ministerial exception is a good thing. I think we agree on that. But it's a question of refining it around the edges to avoid some of these anomalous outcomes. That being said, the case we were going to talk about, I don't know if Linwood Cristiello, I think that was right down the middle. But let me stop for your questions.
Well, let's talk about that case, because I could go off on the answer too, but time is of the essence. So let's find out what this case is about.
So Cristiello involved a woman who taught in an elementary school in New Jersey. I get people upset with me when I say this, but you know why people in Manhattan are depressed all the time? The light at the other end of the tunnel leads to Jersey.
As a New Yorker, I absolutely agree. Except after 9/11, everything changed because now we love New Jersey.
Well, I wouldn't go that far. We had a chance to go back to New York some years ago. My wife, who grew up on Long Island, said, "Oh, we can always live in New Jersey." And I just looked at her. Was it serious? Anyway, a young woman taught in a Catholic high school. She was kind of an aide, not kind of, she was an aide, was asked to take on a position as a regular teacher. When she was offered the position, she said, "Well, I'm going to need some more money because I'm pregnant." However, she was not married. And watching out for the lightning bolt striking me when I say this, unless your name is Mary and an angel came to visit you, that's not kosher to mix metaphors in the Catholic Church, so they dismissed her. Lower courts ruled in her favor, and New Jersey has a law like the ministerial exception. They just call it the religious tenets exception, but it's a ministerial exception. And the Jersey Supreme Court ruled that school officials had the authority to fire her because church teachings on that point are pretty clear. I don't think anybody who is Roman Catholic or many mainline Christian positions, and I believe it's the same in the LDS Church, that you don't have children out of wedlock. That's kind of a given. But another part that I raised in this article and elsewhere, I would say is a matter of simple contract law. When she signed the contract, she agreed to abide by the terms and conditions of her employer, one of which are that she not have children outside of marriage. Now, that being said, I had a conversation a while back online about something else I wrote with a classmate of mine from high school that was very critical of the current Pope. And she said, "Oh my God, you call yourself a Catholic questioning the Pope." But I think that's part of what it is to be an academic. But in this situation, she knew the rules. There was no question. And she freely signed that contract. So this friend of mine said, "Well, would you rather she have an abortion?" And I said, that's not the issue. The issue is not abort or keep your job. If she would have had an abortion and spoken about it, I would say that's grounds for dismissal as well. But she signed a contract in which she agreed to comply with the policies of her school and the diocese in compliance with the Roman Catholic Church teachings. So I have a hard time finding that to be discriminatory. As you probably know, Bettina, you know better than I do, in Australia, they talk about, positive discrimination, which might be, in a sense, a ministerial exception. If you want to call this positive discrimination, then so be it. But I'd rather not put the word discrimination as much as I prefer to see it as protecting the sanctity of the authority of faith-based leaders. And in this case, not in all the others, combined with the fact that she voluntarily and knowingly signed a contract that included certain conditions. If she didn't agree with the conditions, freedom of contract, don't sign the contract.
You know, Charlie, one of my mentors was a Seventh-day Adventist attorney who litigated a lot of the Establishment Clause cases back in the 80s and 90s, and involving, religion in the schools and parochial cases and such. And one of the things that Lee Boothby taught me said, if you have a religious school and you want to secularize, it's easy. All you have to do is nothing. It will happen all by itself. But if you want to maintain the spiritual vitality of a faith-based school, it's hard, and you have to be very intentional. And I think the statutory protections that we have for religious institutions at least support our ability to make the effort to maintain the spiritual foundations of our religious institutions. It's not an easy task, and we're not always very good at it. And I have to say that Lee pointed to what was happening with Roman Catholic institutions of higher education like Georgetown as examples of secularization and things that he hoped that our Seventh-day Adventist schools did not follow.
I think we've all diagnosed problems with the current formulation for the ministerial exception, but as far as I can tell, no one's come up with any solutions. But you've described the problems very clearly, and also the benefits of the ministerial exception. So perhaps, Alan, we need to do a part 2. Okay. Well, thank you, Charlie, for at least making our audience aware of what the ministerial exception is, and we'll look forward to talking to you another time.
Look forward to it, Bettina. And Alan, thanks very much for your time. It was a pleasure chatting with you.
So, Alan, I'm coming away from that interview with the sense that this is just a huge issue. Yes, religious schools need the ability to maintain their identity, but there are so many other areas where it seems like there's an overstepping of the bounds, right?
So this Supreme Court has really gone overboard in, I think, a traditional Roman Catholic approach to church autonomy, which is, an almost absolute kind of, the state doesn't mess with the church at all. And, the end result is that tens of thousands of church school employees have lost virtually all of their employment rights.
Yeah. But on the other hand, Alan, I mean, there is a sense that you do not want courts with their fingers in, the religious issues, trying to sort out what's secular, what's subject to civil jurisdiction,
Correct.
And what's, properly within. And that's
not the ministerial exception. That's the Title VII religious employer. So the Title VII religious employer protection says that a religious employer, a church school, church, can make a religious decision.
Yeah.
You got divorced, we don't believe in divorce.
Yeah.
You got pregnant out of wedlock, we don't believe in getting pregnant out of wedlock.
Yeah.
Whatever it is, if it's a religious-based decision, the courts don't have jurisdiction.
But the ministerial exception turns on the question of who is a minister, which is to a large degree a religious issue. So you still have to get in there and sort out what is religious and what is civil when you determine who is a minister, right?
Well, but if you start with those who are actually clergy,
right?
That's a clear line.
Yeah,
a teacher is a teacher. A teacher is not a minister.
Okay, we can have a good old argument about this, because if I'm sending my child to an elementary school that's run by a faith-based organization, I want those teachers to be ministers in the sense that they are inculcating religion and the faith of that school in my child, correct?
Okay.
So that's the function of a minister, even though they are ostensibly a teacher.
So should they lose their right not to be discriminated against because of disability or gender or race?
And that's where the tension comes in.
Right. So, I function in a very strange space, Bettina, because on the one hand, As a representative of the Seventh-day Adventist Church, I'm very protective of Adventist education and of the rights of our denomination, our bodies, to make faith-based decisions, right? On the other hand, I represent workers who suffer religious discrimination, so I'm very pro-work.
Yeah. Well, in other words, we're not going to settle this today.
No.
No.
So, to be continued, this has been Just Liberty, where justice and liberty meet. I'm Alan Reinach here with Bettina Krause. Until next time, remember,
Eternal vigilance is the price of liberty.